Thank you so much and welcome to today's webinar, Late Career Provider Policies, the Current Legal Landscape. We really appreciate you joining us today. I'm Sharon Beckwith. I'm President of Peer Review and Clinical Quality Consulting at MD Review, which is a Hardenbergh company, and I'll be the moderator today for the program. Today's webinar is being sponsored and hosted by the Hardenbergh Group and MD Review. So before we get going, I'd just like to share a couple of housekeeping details with you all. All of your microphones, all attendee microphones have been muted for the presentation. To ask questions of our presenters, please go ahead and use the Q&A icon located on the navigation bar. Generally, it's either at the bottom of your screen or the top of your screen, and just type your question in there. We will leave some time, and as time permits at the end of the program, to go ahead and answer those questions. I'll read the submitted questions and ask our presenters to respond to those. Your NAMSS-approved CE certificate will be emailed to you within 48 hours directly from Hardenbergh in your thank you for attending follow-up email. So please be on the lookout for that. Also included in the email will be the slides from today's presentation and a link to a short survey. We really would love it if you would just take a few minutes to share your feedback. We really do value it so greatly. And now it's my pleasure to introduce our two presenters today, Rick Barton and Rachel Harrington, who are both from the law firm Procopio. So Rick Barton has represented healthcare providers and healthcare systems for more than 40 years. His consulting and litigation practice focuses on health systems, hospitals, health associations, physician groups, and individual healthcare providers. He's experienced in assisting provider organizations with their quality oversight, compliance obligations, and governance. He also serves as an adjunct law professor for the University of San Diego Law School, teaching health law and policy. So thanks so much, Rick, for being with us here today. Rachel Harrington provides counsel to hospitals, medical staffs, and physician groups with a focus on bylaw and policy review and development of corrective action, medical staff credentialing and privileging, and fair hearing procedures. She assists medical staffs in their corrective action and peer review processes and represents medical staffs in judicial review hearings. We welcome both Rick and Rachel. It's great to have you here with us. And now I'm going to go ahead and turn it over to Rachel, who's going to go ahead and get us started.
Right. Hi, everybody. I just want to take a moment to further introduce Rick, our primary speaker, and introduce the topic that's in front of us today. Rick has been a thought leader in this area for quite some time and has really put forward a lot of the legal analysis and arguments supporting these late career provider policies and developing the policies. That's demonstrated in part by, I believe it's a 2014 white paper on the topic. And now fast forward to today, we're seeing those legal arguments being put to the test in the courts, and we're seeing the policies under scrutiny from the EEOC, and it's really a fascinating time to see that play out. In addition, what makes this interesting is we're at a time where we're seeing an increase in the population of aging physicians as well as a provider shortage. So here we are needing our providers that have experience and knowledge throughout their age and experience, but at the same time, science informs us, whether or not we want to hear it, science informs us that as we age, there inherently are changes to our physical and mental health capacities. And these late career provider policies are designed to identify latent health risks that pose a risk to our patients, and not to necessarily result in adverse action to a provider's privileges, but to really identify a health risk and work with that provider to find a way to address it and have that provider provide safe care and continue his or her practice, not to go down a road of adverse action. It's really a proactive approach to peer review that is very helpful for us, especially in current circumstances. Unfortunately, under the current legal landscape, we're seeing an immediate impact of medical staff, professionals, and healthcare facilities telling us, we have one of these policies, but we have decided it's best not to implement it right now. Or we've heard from a number of other MSPs and healthcare facilities, we really want these policies. We want to adopt it. We see its benefit. And we aren't right now because we don't want EEOC oversight. So it's a time where we're seeing an immediate impact where people are stepping away from it as we see this play out in the courts. In the larger picture, there could be greater impacts to peer review depending on what the outcome of current litigation is. It could be a minor impact, and it could be fairly significant impacts on how we conduct our peer review across the country. So it's a fairly important topic, and the current legal landscape is one for us to watch. So with that said, our learning objectives today are: 1, understanding the current legal landscape of the ongoing litigation; 2, considering the purpose for adopting a late career provider policy and exploring how these policies can be implemented in conjunction with our bylaws; and then finally exploring some of the legal and public policy arguments for adopting and implementing these policies. And on that note, I'm going to turn it over to Rick Barton to get us into understanding the current legal landscape of the ongoing litigation.
Thanks so much, Rachel and Sharon. It's really, I'm so pleased to be with everyone today. I'm coming to you actually from San Francisco, where I'm attending the American Health Law Association annual meeting. At the beginning of the conference, they do a 2-hour overview of current legal issues confronting the health law environment. And so we've been discussing everything from Dobbs to issues involving mergers and acquisitions and all sorts of related healthcare topics. But when they turned to the medical staff credentialing and privileging topic, they immediately focused on this case, telling the audience there's about 500 lawyers here. This is an important case that is coming down the road, and to watch this case. So we couldn't be more timely with all of this in terms of our discussion. I will say that when I first was involved in studying the issue, one of the primary questions that I got, simply because I am an attorney, is, well, if we decide that we're going to do or implement one of these policies, adopt a policy, is it legal? And my honest answer was, I can't tell you that until we actually have some law developed within this specific context. We know that there is a very large body of law that deals with age-related retirement and screening in other industries dealing with public safety. So what I did in my initial efforts on this is took a deep dive into the legal landscape with respect to pilots and bus drivers and law enforcement and judges and other occupations where the law has recognized the ability for either industries or for the government itself to mandate retirement at particular ages, notwithstanding the prohibition against age discrimination. And so in studying all of that, I came to certain conclusions with respect to what the arguments would look like if the case was ever litigated. But the reality is that this particular effort by the EEOC is the very first that we've seen of a government agency taking the position that these that late career practitioner policies, screening policies, violate the various provisions that we're going to talk about. So let's go to the next slide. Couple of things to understand about the EEOC, and that is that it is a federal agency responsible for the enforcement of federal law with respect to discrimination in employment. So the EEOC oversees issues involving discrimination of all sorts of types: color, race, religion, ethnicity, sex, sexual preference. All of that is within the umbrella of the EEOC and their enforcement mandate. And the Civil Rights Act of 1964, Title VII, was the sort of the beginning of the federal law with regard to employment discrimination. What you will note is that the Americans with Disabilities Act and the Age Discrimination in Employment Act, which are the two laws that the EEOC is relying upon, are not part of the original Civil Rights Act. And I'm going to explain to you why that is in a moment. The other part of it being a federal agency is that this does not necessarily mean that state laws and state legislatures, state agencies, and state courts cannot review these. That is, right now, we are in the federal jurisdiction, and with the EEOC, a federal agency seeking to enforce these particular laws regarding these policies. There are other ways in which discrimination claims can come before courts. One is that all states have their own age discrimination and disability discrimination statutes. And so one of the things that I always was sort of watching for in this is whether or not an individual physician might bring a lawsuit in a state court alleging that a late career practitioner policy was discriminatory under state law. So the fact that it is in federal court brings certain things to this, because we'll talk about what's authoritative and what isn't when a federal court is asked to decide something. But the EEOC action doesn't necessarily preclude a physician or some other entity from, or an agency from bringing their own action in state court, trying to enforce state anti-discrimination laws. The reason that I highlighted that the laws that they're seeking to enforce in this case is the Americans with Disabilities Act and the Age Discrimination in Employment Act is because these two particular laws have a characteristic which is different from other anti-discrimination laws. So the discrimination laws with respect to color and race, ethnicity, religion, sex, they deal with what is called immutable characteristics, which are characteristics that we can't change as individuals. So the fact that you may be of a particular religion or a particular race or ethnicity, that should not impact your ability to perform your work and to perform your work safely. The reason that the Disabilities Act and the Employment Act are different is because we do know that in the context of employment, that a disability may render someone unqualified to do the job, either because their ability to perform the job proficiently is impacted by their disability, or because it raises safety concerns for others in the employment context or to themselves. The same thing goes with age discrimination. We know, and this is sort of the basic premise of all of this, is that we are all going to age. We are all going to suffer from some sort of decline or experience some sort of decline because of our age. And so the reason that the federal law recognizes the ability to retire a pilot at the age of 65 is because federal law and Congress has decided that the safety issues that arise from age-related decline are sufficient to allow an age-based type of rule that prohibits someone from doing that work beyond a particular age. So if we go to the next slide. So we are aware of two specific issues with respect to EEOC actions. So the first is with respect to Hennepin. So Hennepin is obviously in Minnesota, and the way that the EEOC operates is individuals can come to the EEOC and say, look, I believe that I have been subjected to some form of discrimination which is covered by federal law. And the EEOC could say to that individual, look, you just need to take action on your own. So you as an individual, Dr. Smith or Dr. Jones, we as a government agency are not going to seek to enforce this on your behalf, but that doesn't preclude you from seeking your own individual remedies in court for any violation of federal law. The EEOC will take on certain issues if they feel they have particular importance, and that's what has happened here. So in both the Hennepin and the Yale New Haven case, what happened is that individual physicians approached the EEOC and asked whether the EEOC would take on this issue. And so what the EEOC does is it doesn't necessarily start with a lawsuit. What it will do is it will send a letter to the entity that they believe is violating federal law. And then what happens is they will engage in what's called a conciliation process. And that conciliation process is really like settlement negotiations, where there can be an agreement that is reached between the entity and the government with respect to what will be done with respect to whatever actions have been taken that the EEOC may feel are discriminatory. So for instance, you could narrow the scope of a particular program or some sort of policy that you have with respect to particular employees. In the case of Hennepin, what they had elected to do during the conciliation process was to enter into a resolution with the EEOC whereby they would withdraw their late career practitioner policy. So in the Yale New Haven case, what occurred was there was a conciliation process that went on for many months. And Yale New Haven Hospital took the position that they did not want to withdraw their policy, that they could choose, or that they elected to essentially defend the policy in court. And so that is what resulted in the complaint that was filed by the EEOC in the United States District Court for Connecticut, essentially seeking a court determination that the Yale New Haven late career practitioner policy was discriminatory under the Americans with Disabilities Act and the Age Discrimination and Employment Act. And what we have here is the actual language from the complaint as to what the EEOC is alleging in the lawsuit. And basically the LCP policy requires that any individual over the age of 70 and older who applies for or seeks to renew medical staff privileges at Yale New Haven Hospital take both an ophthalmologic and a neuropsychological medical exam. There was another component to the Yale New Haven program, which was a more focused peer review. And then the policy itself is rather lengthy, and we'll talk about sort of what the policy itself requires. But what should be noted is part of the discussion in the case is that this was not a mandatory retirement program. This was simply a program that was designed, like so many other policies across the country, that have either been adopted by institutions or and implemented by institutions. And it basically seeks to identify those who may have an existing potential impairment that may impact their ability to provide safe care. And then there is a whole process that involves both well-being committee, potentially, and this isn't with respect to Yale New Haven specifically, but we've seen policies where the pathway is to go through well-being committee, others where it goes through a specific focused peer review, and then a program where there's some discussion and engagement with the individual clinician who's been identified with a particular issue that causes concern, and then some resolution through that conciliation process taking place within the individual institution. So if we go to the next slide. Here's the basic principles of what the EEOC complaint alleges against the Yale New Haven hospital policy. It is what they alleged in the Hennepin case. It is their established now policy with regard to late career practitioner policies, and the litigation that they are bringing in with respect to Yale New Haven does not preclude them from also sending letters to other institutions around the country. So the reason that we are discussing this, and that may have already occurred and it just hasn't bubbled up to us, but what we're really looking at is the federal government's position with respect to late career practitioner policies, and this is going to be adjudicated in federal district court. Next slide. Here's what the Americans with Disability Act says, and what the allegation is in the EEOC position. And it basically has to do with when can an employer actually require a medical examination of an employee. And the standard that is used is that an employer can't require a medical examination, which the EEOC considers the late career screening policy to be, to take place unless the examination is shown to be job related and consistent with business necessity. So next slide. So essentially, the purpose of the ADA was to prohibit not only discriminatory actions by employers against those with disabilities in terms of termination or other form of adverse action, but it actually, Congress sought to prohibit even questions or demands regarding an employee or a potential employee's disability. And so you can see the statement in this case where it says this broad protection reflects Congress's efforts to curtail all questioning that would serve to identify and exclude persons with disabilities from consideration for employment. So and then we go on to the next paragraph, which is comes from another case where basically it says, look, you can request that an employee undergo a medical examination where you have a reasonable basis for believing that the employee is unable to perform the essential functions of their job, or that they pose a direct threat to their own safety or the safety of others. Next slide. With respect to the ADA, the EEOC has taken the position that medical screening exams are not job-related and consistent with business necessity. Why? Because hospitals and medical staffs have non-discriminatory means of identifying practitioners suffering from impairment, age-related or otherwise, through its peer review and quality improvement systems. In both the Hennepin matter and in the Yale New Haven matter, the primary arguments are that, look, you have this very well-established peer review system that is in place for identifying when a disability, either on its own or related to age, may impact the ability of a practitioner to safely practice. And when you look at some of the things that the EEOC is saying in its briefs in the Yale New Haven action, it praises Yale New Haven for being on the forefront of developing a program for monitoring its practitioners, going through the credentialing process, being proactive with respect to intervening when certain problems are identified with patient care or observations of behavior. And so you have this kind of interesting dynamic in a court where instead of the government agency talking about how deficient a particular entity is that it believes is discriminatory, actually what the government is saying in not just the Yale case, but in all cases is, look, you have this peer review system. And so if you have a clinician that may be suffering from some impairment, you have the ability to identify them through your quality improvement reporting programs, through your peer review programs. You can see whether or not somebody is practicing in a manner which is consistent with the standard of care. So you don't need to use age as a factor. You have this structure in place that allows you to identify these things. And doing this just simply based upon the fact that someone may have an age-related impairment simply is unnecessary. And then the other thing that they have alleged is that, and we talked about in the context of the ADA, where you have a disability which is creating a direct threat. They basically are saying, look, you can't establish that there is a direct threat to patients based solely on age, that everybody ages differently. There are all sorts of variations in the way that age impacts all of us, including physicians. And you can't say that just simply because somebody is over a particular age that they are a direct threat. Next slide. Under the ADEA, so the Age Discrimination in Employment Act, so an employer implementing an age-based policy must establish that the job qualifications which the employer invokes to justify the age-based policy, that is what what's at issue with regard to the discrimination, is reasonably necessary to the essence of the business, and that the entity is compelled to rely on age as a proxy for those safety-related job qualifications. And obviously a job qualification would be you are safe to do the job. That is, you're safe from the standpoint of your own safety, and also that others that may be impacted by your performance are also safe. And then you have this case that was a case in 1986 where you see this language where it says that a defendant, an entity, must show that it had to use age as a proxy, in this case for patient safety, because it would have been impossible or highly impractical to deal with older employees on an individualized basis. And so again, what the EEOC is doing is relying upon the existence of the peer review system to say, no, look, it's not impossible or highly impractical for you to deal with older employees on an individualized basis. That's what the peer review system is. So therefore, the only basis upon which you can use age would be to show that it's impossible or highly impractical to identify older employees who may be suffering from an impairment. That's a very high standard, and we're going to see sort of how the courts have dealt with that when we discuss this a little bit later on. Next slide. So the defense in both the Age Discrimination and Employment Act and the ADA is basically it's not unlawful for an employer or an agency to establish a particular qualification that may be related to their status, where age is a bona fide, and in our case, is where it's a bona fide occupational qualification reasonably necessary to the normal operation of the particular business. So stepping outside of the age discrimination arena, there are a lot of cases where, for instance, an employer may say, look, we need an individual of a particular gender to be performing this job. That a lot of cases in cases involving law enforcement, involving prison guards, where basically they will allow law enforcement agencies to use women in certain roles where other women are involved, where basically the position is, look, we don't want men in these particular arenas or these particular contexts simply because of these other factors. And so where the courts have adjudicated whether or not gender itself can be a way of essentially where they would allow that sort of differentiation because of other factors dealing with the particular employment context. So age can be a bona fide occupational qualification if it's reasonably necessary to the normal operation of the particular business. And the EEOC's position is that age is not a bona fide occupational qualification reasonably necessary to the normal operation of a hospital. Next slide. So here's sort of a restatement of what I just said. Their medical screening exams are not reasonably necessary to the essence of the hospital business, and hospitals are not compelled to rely on age as a proxy. And then the next paragraph is what I've been talking about before. Next slide. So what is the current status of the EEOC litigation? So as we said, Hennepin, they resolved their case. They chose to seek a resolution with the EEOC so that essentially they did not have to go into court and defend their the policy. Yale New Haven Hospital has chosen to defend its policy. And so what happened with the complaint, like in every case, there is a process of discovery where depositions are taken, and there is a fact-finding process that both sides engage in. So in the Yale New Haven case, many depositions have been taken, and specifically depositions have been taken of the experts who have been designated by both the EEOC and Yale New Haven Hospital to come and testify and explain to the court the position that they are supporting in the litigation. And so these depositions have been taken. They've lasted quite some time, many of them multiple volumes. And so those depositions, the expert depositions, have been for the most part completed. And then what the court asked the parties is, do you want to file motions that will allow the court to essentially render a judgment based upon the facts that you develop through the discovery process? And so motions for summary judgment have been filed by both sides. And in this case, the EEOC is saying, look, we have the discovery, we have the evidence through the discovery process, through depositions and otherwise, and we can tell you, court, that this particular policy is discriminatory and that you, the district court, can actually make that determination on your own. Similarly, Yale New Haven has filed its own motion to say, no, this is not discriminatory for the following reasons, citing the expert testimony, citing all the factors that we're going to talk about. And you, court, you can render a decision dismissing the EEOC action because the Yale New Haven policy, because of the facts and federal law, does not render this policy violative of the ADA and the ADEA. So there is no motion hearing date set. The court, we anticipate that that date will be set in the fall. So the options for the court are that it can grant the EEOC motion and say this is a discriminatory policy under either the ADA or the ADEA. It could grant the Yale New Haven Hospital motion saying, no, we don't think, based on the discovery and the evidence that we have before us, that this violates these prohibitions. or the court could deny the motions in order a trial for further evidence, where the court would take evidence. They could do a jury trial, they could do a bench trial, but essentially the court could say, look, I need more evidence, we need to take this to trial. And then any of the above outcomes can then result in an appeal to the U.S. Circuit Court of Appeal in the Second Circuit, which is where the district court in Connecticut resides. And if either party wants to seek further review, it could go to the United States Supreme Court. One of the most important things to know about a district court ruling on this is how authoritative it is for other courts. So when a district court issues an opinion, either on a motion or after a trial, it will issue a written decision. And that written decision can be cited in other cases, but it is not necessarily authoritative for other courts, either federal courts or state courts. When it goes up to the U.S. Circuit Court of Appeal, that when the U.S. Circuit Court of Appeal rules on an issue, that ruling can be authoritative in the particular circuit. It can also be cited as authoritative, but not necessarily controlling in another circuit. And the same goes for state court. You can cite a federal ruling in the Circuit Court of Appeal as authoritative, but not necessarily binding on another federal court or another state court. There are conflicting decisions in circuit courts on the exact same type of question. And many times what happens is that becomes a basis for Supreme Court review. That is, the Second Circuit says this, the Ninth Circuit out in California and the West Coast says that. It's an important question. We're going to take it up to resolve that conflict. Next slide. So here's what the responses are. And for those of you who know, my office was asked by Yale New Haven to assist in the filing of an amicus brief to the court to basically bring to bear the arguments of those entities that have been involved in the study of this particular issue for many years. So here's the basic outlines of the response to the EEOC. First of all and foremost, this is a patient safety issue. And that, the most important piece of this is that when you read the EEOC complaint, it is, and not incorrectly, very physician focused. It is, look, these physicians are being burdened by your imposition of this requirement on them. And, you haven't shown us that you have a proper justification for this. And so the response is that, look, we understand, and certainly no one wants to discriminate based upon age or disability against any clinician working in the setting of a hospital. All institutions are dedicated to preventing that. However, we know that the law allows for particular exceptions to these laws when public safety is an issue. And court, you need to understand that this truly is a patient safety issue. We as hospitals are legally mandated to ensure the quality of care provided to patients by practitioners. We know that the health of a practitioner is an essential part of the credentialing and privileging process. And that we as institutions are required by federal law, by the Joint Commission and other accreditation agencies to essentially take steps if we identify a practitioner that may have a health-related issue that may impact their ability to provide safe care. And the other part of the argument is that, look, the law has always deferred to physicians and other professionals to establish the appropriate standards of care and the oversight of quality in hospitals. The next stage of it is to say to the court, look, the science has very, very clearly established that age-related decline can adversely affect practitioner performance and patient outcomes. One of the reasons that the federal government has allowed and state governments have allowed for certain age-based retirement mandates is because they simply accept the idea that age impacts all of us and that age-related decline can impact the ability of an individual to perform their job safely for themselves and for the public. And when it comes to pilots, and when it comes to air traffic controllers, and when it comes to law enforcement, the public safety is specifically implicated in their ability to carry out their responsibilities. But the argument to the court is more focused, and that is, look, there is a huge amount of science which is clearly established that age-related decline can adversely affect practitioner performance and patient outcomes. We're saying to the court, look, it isn't simply that age-related decline can impact performance as a general matter. It's that, look at, here are all of these studies in which people have looked at this issue and have clearly demonstrated a correlation between age-related decline and patient outcomes in certain specialties, procedure-based medicine, and other aspects of the provision of medical care. And then a subcomponent of that is that we use age in all aspects of providing healthcare. In all of us are subjected to or are allowed to or recommended to undergo testing at certain ages because we know that age impacts the potential risk-benefit analysis of whether or not you undergo a colonoscopy every 3 years or 5 years, whether you undergo breast cancer screening at particular age. Age is always used in medicine. And so this is not something which is unique. And then the next argument really is that, look, for whatever the government wants to say about our peer review and performance monitoring systems, they are never perfect. And we'll talk about some of the evidence that's been brought to bear in the litigation with respect to this particular aspect. And again, you have this kind of interesting dynamic where the government is praising hospitals and the peer review system and saying that's enough. And the defendant in the case is coming back and saying, well, it may not necessarily be enough, which is not necessarily how you see most litigation being, sort of playing out. And then finally, the argument is that when public safety is at risk, the law has never viewed the ADA and the ADEA as absolute prohibitions against using disability and age as factors in settings where public safety is at risk. All right, so next slide. Part of this is that, priceless is a single life in our concept in the value of human life. And that if these programs are designed to sort of identify impairments, because every patient that comes in is entitled to rely upon the institution to make sure that their life is being protected. And I will tell you that in one of the depositions in the Yale New Haven case, the questions that was asked is, well, how does the Yale New Haven program differ from an airline or a pilot? And the expert in the case, the response was, well, when we're a pilot, you have a whole plane going down, a plane load of people going down. Whereas here, and that response is just really sort of jarring if you think about it. Next slide. So this is a case that it was in California, and basically the court in that case said, and it didn't have anything to do with an LCP policy, but it had to do with essentially what the hospital's obligation to protect its patients. And is here the rights of patients to rely on competent medical treatment are directly affected and must always be kept in mind. An analogy between a surgeon and an airline pilot is not inapt. A hospital which closes its eyes to questionable competence and resolves all doubts in favor of the doctor does so at the peril of the public. Next slide. And here's another sort of standard. Greyhound need only demonstrate a minimal increase in risk of harm for it is enough to show that elimination of the hiring policy might jeopardize the life of one or more person that might otherwise occur under the present hiring practice. In the Hodgson case, the bus company had a policy where it would essentially not hire bus drivers past the age of 35, and then it would mandatorily retire them. And basically the argument was, well, gee, you have these other factors in place. And the court, as opposed to adopting this standard of, that the entity has to show that it's impossible or highly impractical for the entity to use some other mechanisms for identifying whether or not you can establish the requirement of this policy. Here, what the court is saying is, look, the bus drivers, the Greyhound need only come in and show that individuals are going to be potentially impacted by a potentially unsafe bus driver. It doesn't require that you show that this practice is causing death to scores of people, et cetera. Go ahead. Here are the AMA statistics on aging physician. Everybody knows this. You can go to the next slide, because I know we're running close on time. One of the points that we made is look, that patients don't select their providers in the hospital setting in many cases, that the majority of hospitalized patients will be treated by an increasing number of older practitioners they will not select and they will never meet. And that, like passengers boarding a plane or a bus, hospital and patients are entirely reliant on medical staff quality improvement and peer review systems to ensure providers are capable of providing safe and appropriate care. Next slide. Here's the purpose of late career provider policies. And we cited Dr. Rao because Dr. Rao was the chairman of the Council on Medical Education of the American Medical Association. And they actually came out with guiding principles and appropriate criteria for assessing physicians. And they endorsed the use of late career practitioner policies. And so this particular quote is important, not simply on its because of its substance, but also because it served as the basis for the AMA CME recommending that physicians be screened at the age of 65. Let's go to the next slide. And then self-regulation is an important aspect. So really, these guidelines should be based on principles of medical ethics. That was set forth in the AMA CME report. Next slide. Here's an example of other programs that hospitals have had in place for many years. We made clear that the court understood that this is not new. Next slide. And then the idea is that peer review is imperfect. And so here's a quote from an article that was written about aging surgeons. And the idea is that we don't, and all of us who work in this area understand that we aren't always able to identify when somebody may be suffering from an age-related impairment or some other type of impairment. And so it talks about one reason for the lack of reporting is that younger physicians do not feel comfortable reporting senior physicians. Next line. And then the other part of it is to bring to the court the science, which is studied whether or not individuals will or will not report their colleagues working in the hospital setting. It isn't just simply that we're assuming that this is the case. We actually have studied this, and that we have seen that there are individuals in that last paragraph, 17% of physicians reported direct personal knowledge of a colleague whom they regarded as incompetent, but acknowledged that they had taken no action, citing the belief that someone else was taking care of the problem, the belief that nothing would happen as a result of the report, or the fear of retribution. Next slide. Next slide. And then the final part of the argument is that, look, we can't wait for patients to be harmed. And here's Dr. Sataloff again writing in an article in a journal. It seems self-evident that if we wait to take action until after a previously excellent surgeon has been sued repeatedly for bad outcomes, then we have waited too long and have failed the patient's hospital and the aging surgeon. Next slide. So here's where the other industries come into play. Next slide. And obviously you can all take a look at this. Commercial airline pilots mandatorily retired at the age of 65, and mandated medical certification examinations upon hiring every year. So one of the most important parts of this is that the Yale or the EEOC has relied upon the idea that we have this entire peer review structure that allows us to identify clinicians who may have deficiencies in their ability to perform, and that should serve as the basis for catching any problems. And so one of the things that's important to point out to the court is that, look, the federal government, this is a federal statute which mandates the retirement of pilots at the age of 65. Not only do they mandate retirement at age of 65, but they also mandate medical certification examinations. And oh, by the way, they increase in frequency based upon a particular age. And the other argument is to the court is, look, all of the industries that have imposed these age-based retirement policies also have a quality improvement and performance monitoring system. So to say that the peer review system should suffice in the case of healthcare providers is to ignore the fact that the federal government and other agencies have believed that no, that this particular type of mandatory retirement at a certain age provides an extra layer of protection for the public. It's not like pilots just simply fly airplanes and are never monitored for mistakes or problems or impairment or anything like that. They're constantly monitored throughout their careers for these types of things. And to say that the hospital peer review system should suffice is to ignore the fact that the law has very clearly said that it's all of it which should be allowed when the public safety is at risk. Next slide. Here's also the air traffic controllers. This is federal law. Next slide. Here is federal and state law enforcement, a number of different authorities. Here's bus drivers, and the particular issue here is the idea that that it was the industry itself that established these age-based restrictions, and the argument is it's the hospital industry which is imposing these particular age-based restrictions. It's not necessarily the government mandating it. So finally, it's that we're not arguing that the age-based screening for practitioners should be mandatory. We're arguing that the court refrain from holding that prohibits physician leadership responsible for the safety of patients from implementing an evidence-based program to measure neurocognitive and other changes as a component of its legally mandated quality oversight function. And so with that, we will turn to Q&A. I appreciate your patience in getting through all that material.
Thanks so much, Rick. Totally appreciate it. We do have some great comments and some questions. So I'm just going to kind of start off with a few comments. And it really ties back to what you were talking about in peer review. And that is, if the hospital medical staff have to rely on peer review process to identify physicians with aging factors, it sounds like we have to wait for an issue or a bad outcome, right? And surely there's a better way to do this. And we talk about it all the time, right? There's a better and more proactive way to go about this.
Right. Yeah. And I mean, you can say that even health examinations that we do, even with us, something which is suspected, is burdening the clinician with some, requirement. But no, the whole idea is this has to be proactive and to identify these issues before someone gets hurt.
Absolutely. So here's a good question. So how do you then keep peer review separate from issues regarding aging, specifically as it relates to health issues or impairments?
Yeah, that's a great question. So, and there's been some discussion about, whether or not this is best handled through well-being committees, or it should be handled by medical staff through some separate process. For me, the most important thing is that you have in place a culture within the medical staff, and that you have in place structures, a well-being committee, or a committee that is sensitive to the notion that we don't necessarily want to overreact to these issues, that these things can be resolved, that there are many times in which the practitioner will themselves self-identify, or once you point it out to them, will agree to accept certain limitations on their practice. They may give up certain privileges. The other thing that can be done is you can rely upon outside organizations. We know CPEP and PACE. They provide for the program specifically for dealing with clinicians who are suspected of having certain issues relating to age-related decline. So you really need to sort of develop a culture where it is to assist the clinician first and foremost, either in recognizing what the impairment or the issue might be, and then taking the appropriate steps through a non-disciplinary means of addressing it, either through your own internal processes or externally. You want the clinician to essentially come to their own conclusions. But at the same time, if that clinician is resistant and is not essentially abiding by some of the recommendations, then you may need to take some of these more disciplinary steps to impose certain restrictions. But the first step should be to work with the clinician and help them through the process.
So, and I absolutely agree with you, but we all know that some physicians are very open to hearing feedback and others are not so open, and others really lack that sort of introspection and self-insight. So as it relates to all of this, how much information related to aging or health issues should you share with your credentials committee if the issues are affecting their privileges? So should it be just a short summary without details? Should it have specific details? What is appropriate to share with that credentials committee?
So, I think that if you that initially it should be as part of the credentialing process and the privileging process is if there is someone who you believe where age is creating an issue, then the credentials committee needs to be alerted to that. As far as the sharing of information, you do have to be careful, because it may be that the credentials committee basically says, well, maybe we send it back to the well-being committee so that you can sort of maintain the confidentiality of all the different components of what may be at place, and allow a more confidential process to deal with it, so that if the physician does, all of a sudden the light bulb goes off or goes on, and they then become sort of willing to take the steps, then you've kept that information from sort of the credentialing committee or the MEC and anything else. So to me, it would be to highlight that, look, we are having these issues. We may have some things to do with it, to deal with this, and allow for the credentials committee to maybe use it as a referral back to well-being, or to kick it up to MEC so that they can use the well-being committee.
Right. And then, of course, there's always questions about MPDB, right? So what do you do? Do you report to the MPDB if privileges are reduced or if they're voluntarily relinquished due to aging?
Yeah, so and this goes into sort of if it's performance related or something else, right? In California, we have medical disciplinary cause a reason. And I think that is all individual based upon how it comes up. That is, if you have performance issues where you have identified someone and it has come through the peer review process where you can actually identify a quality of care issue, then you may be required to report that to the NPDB if you do then come to some understanding of a restriction in privileges. But on the other hand, again, if these are identified simply by behavior or observation, it may be that you have an opportunity to take some action, which is not necessarily based on performance. It's simply a health-related issue like anything else, and you're not necessarily going to have to report that if there's some agreement with regard to restrictions.
Perfect. I've got a couple more for you. Oh yeah, go ahead, Rachel.
Bouncing off of that, a question we also get a lot related to that is, where does the investigation component fit into this? And the idea is, if you have this policy in place and you're making it part of your routine peer review as a routine screening, when someone hits that marker, it's not an investigation and it's just another routine process in your peer review. And then once an issue, if an issue is identified as part of that screening process, you then route it, as Rick was saying, to the well-being committee or the credentials committee, whatever the appropriate committee is to hear and help resolve that issue. And then we can keep it out of that focused, targeted investigation and review for corrective action. And it might ultimately lead to some sort of corrective action, but we can keep it out of that investigation land.
Great. You know, and all these questions, as you can imagine, really sort of tie together. So kind of playing off of that, Rachel, what has been your experience in the hospitals that you have worked with, or your recommendation with this the idea of like a fitness for duty evaluation versus an actual aging policy?
Yeah, so I will tell you that many of the hospitals that I have worked with, they have been reluctant to have an age-based screening program. The arguments are that that you could get a lot of false positives, that essentially it's not an efficient way. They question the reliability of the testing, and that we're just simply going to rely upon the peer review process. Other hospitals obviously have been much more willing to adopt these programs, because they do feel, and their medical staffs have agreed, that essentially it does give them another tool in identifying those who may create a risk. One of the things that we did here in discussing this with a lot of the different institutions that have imposed this is the difference is made sort of in the process that you take before you implement it, getting a lot of input, making sure that everybody understands why this is being done, that this is non-threatening, non-disciplinary. It is simply a way of us identifying these potential issues.
Yeah. So are you seeing organizations that have those practitioner health and wellness committees? Are you seeing them those committees taking more of a proactive approach for these matters and trying to keep it with the health and wellness committee rather than, really kind of identifying it as an aging physician policy?
Well, I mean, when you say aging physician policy, I mean, the policies themselves just simply provide for a screening exam. And so essentially the pathways that are created after the screening exam may yield a result are very different. First of all, the exams themselves are different. Some of them, I know some of them want a more peer review type of a focused peer review evaluation, like an FPPE, where you actually look at the cases. Others do the neurocog, et cetera. So most of the policies that I've seen try and direct this to well-being once that particular clinician is identified as having something of concern. and
Right.
not necessarily well-being, but I mean, in the Yale case, it's actually a committee of particular leaders within the hospital who then are responsible for essentially engaging with the clinician to share the results, engage in a process with respect to, okay, what can we do to accommodate all of these issues? What steps are necessary? And for me, the engagement piece is the most important piece once in these programs.
Sharon, I might be jumping ahead, but related to that, I think I saw a comment on how you deal with surgeons versus non-procedural based medicine. And to what Rick was saying, when you bring it to that committee or the wellness committee, that's a component that you do need to look at, is if there is an issue flagged, is it an issue that implicates that specific provider's scope of practice? Because what physical and mental capacities a surgeon needs might be very different from that of a psychiatrist or a hospitalist.
Right, right, exactly. Yeah. So in your experience, have you all seen like what type of reasonable accommodations have been made? And do you have any examples of where a hospital maybe has made some reasonable accommodations for a particular provider?
Oh, yeah. I mean, so what we basically see is, I mean, there's such a wide variety of outcomes when these processes occur. And like I said, some of it is where the physician embraces completely the process, and there is sort of mutual understandings that are come to with respect to what we are going to do in light of whatever findings there are. Sometimes, and Rachel actually hit on this, there might be arguments with respect to the scope of practice. That is, it could be that physician leadership wants the whatever agreement comes out of the interactive process to be broader in scope than the clinician is willing to. And sometimes there will be sort of a, hey, no, I'm not going to agree to that. And then you have to go down the process of essentially attempting to sort of create that kind of an agreement. Either it's imposed upon the physician, or the physician leadership backs off on imposing that. Maybe they put a monitoring requirement in place to sort of follow that particular aspect of the physician's privileges. So there's a wide variety of what we've seen in terms of how these things are put together.
And an example of that that I recently am actually dealing with is, you can take that monitoring and you can also separate it, and you can identify, okay, here's some health issues that we are concerned about. We're going to take this component of monitoring and we're going to send it to the well-being committee. And we want you, provider, to work with the well-being committee on A, B, and C. But we also have some practical concerns and some other issues over here in this other bucket. And we're going to have an FPPE, or we're going to have a proctor in place that sees you retroactively and talks to you about some of your decision making. And so you can also separate it as needed and really look at it on a case-by-case basis to figure out what's best for that particular provider to help them provide the best care.
Great. And I absolutely agree with you. I mean, obviously, peer review is near and dear to me, and just, having, I think having a really good proactive measures in place for all of your providers to identify opportunities, but really working with providers specifically to address the specific needs they might have. I think that's a great option. Okay, one last question for you all. And of course, it's the burning question that everybody has, and I don't think you probably have an answer to it, but I would love to hear what you have to say. How long is this going to go on? Like, when's it going to settle?
Yeah. So, well, I mean, what's very clear is that Yale New Haven, in my opinion, to its great credit, has said, no, we are going to see this through because we believe in our program, and we believe that it is an appropriate way for us to essentially monitor these issues. We don't even have a hearing date for the district court to hear the summary judgment motions. Once the court makes a ruling on those motions, which could also include it ordering, saying, look, I'm not going to decide these, I'm going to send it to trial, then that could take, honestly, a long time. And then getting up to the Second Circuit is going to take quite a long time. I think that what we're hoping for, honestly, is a good start from the court in terms of showing that its receptiveness to the Yale New Haven arguments with respect to this. That I think will help others who are out there who are worried about the legality of all of this. But as to the resolution of this, unfortunately, it may take a while. And that's the unfortunate nature of attempting to of putting these things into the court system.
Yeah. Well, if you all get a crystal ball and figure it out, let us know. All right. Well, again, thank you both so much for joining us today, for sharing your knowledge and expertise with us. We really, really greatly appreciate it. And just to recap for all of our attendees, the slide deck and your CE certifications will be sent out to you by email by Friday. So please keep an eye out for them. All right, everyone, have a great afternoon and a great rest of your week.
Enjoy, everybody. Thank you.